The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon and welcome to the Court of Appeals by WebEx, our virtual court. I'm Chief Judge Donna Stroud, head of the panel today, and with me in court we have Judge Hunter Murphy and Judge Jefferson Griffin. We have one case for argument this afternoon, which is the case of Mabe versus Mabe, and I believe that the appellant, Ms. Reeves, is ready to proceed.
Thank you so much, Your Honor. And if it please the court, I'll go ahead and get started. One of the main issues presented on this appeal today is subject matter jurisdiction in the context of a final order that was entered properly on November 24th of 2015 and a subsequent order on October 22nd of 2019 involving that same subject matter that was entered without authority and without properly conferred subject matter jurisdiction by way of a proper pleading. So as this court is aware, subject matter jurisdiction, it is the indispensable foundation for which judicial decisions rest. And without it, a court just simply has no power to act. And that's on the trial level or the appellate level. And the county's main concern here is, while it involves a paternity, it's not necessarily with the establishment of paternity. Whether that's at the original proceedings or the proceedings that were attempted to be held after. The problem presenting here in this case today, in which the county is trying to prevent from occurring and recurring on a regular basis, is uniformity and compliance with the statutory schemes and the case law on how a party gets to paternity after it's already been established by a lawful order in a previous proceeding. So again, the county has no issue with paternity challenges. We would just like for those challenges to follow the uniform processes set out by axiomatic and long-established case law. So if it please the court, the problem in this court begins and ends with two documents: the appellee's motion and the resulting order. In the county's opinion, they both offend the uniform processes and the uniform application of the rules that have already been mandated by Supreme Court and cited in my brief in the matter of Schway v. Jaber. The rules of civil procedure must be applied equally to all the parties in a lawsuit. That is going to be without regard to whether or not they are represented by counsel. And I raise that because the appellee's counsel raises that in a brief as a basis for this court to relax the standards of how the case gets here and why the appellee is here.
Ms. Reeves,
rules. I'm sorry.
Ms. Reeves, if I could just ask, there's also the appellee brings up the issue of this being an interlocutory appeal. Could you address that first? Because obviously, if it's interlocutory, then we don't have jurisdiction to address it.
Correct, Your Honor. So, Your Honor, in order for this to be an interlocutory order, it actually has to be an order. And on the face of it, yes, it does say order. But if we go to, let's see, my case is here.
Well, I realize you had argued in the brief that it's a void, and I understand that, which would be, you're saying if there's no subject matter jurisdiction to enter the order, then it would be void. But it's either a final order that resolves all issues or it's not. It's pretty obvious that it's not. So on the interlocutory issue.
So on the interlocutory issue, Your Honor, it's not an interlocutory order because the subject matter that it's attempting to litigate has already been litigated. So you have that. And then in the case of Hill v. Manning, where paternity, our courts have said that paternity is not necessarily a final order when those issues are outstanding. So I think that is what distinguishes this case from those cases, is that paternity is established. And in Hill v. Manning, the court does exactly what you're going to do here today. It's not an interlocutory order, and to the extent, even if it was, and this court does have discretion, which was exercised in Hill v. Manning, to look at the previous order, which was a final order, and a subsequent order, and say, hey, this subsequent order has no basis. There's already a final judgment, and they struck that order in the Hill v. Manning case. So, Your Honor, to that end, it's not an interlocutory order.
But I'm looking at your opening brief, and we're usually pretty strict on the argument has to come in the opening brief of some type of substantial right or other grounds for appeal. And the only ground you gave was that it is a final judgment and appeals pursuant to 7A27B. We don't typically allow for a change of the decision or the approach for whether an appeal, whether we have jurisdiction or not, to come in a reply brief. So can you address why you shouldn't be bound to the statement in the brief that this was a final judgment? And I believe that's what's reflected in the amended notice of appeal as well.
Right. And in my amended notice of appeal, I don't believe, let me look at that, Your Honor. I have it up here in my amended notice.
Record page 76 stated the North Carolina Court of Appeals from the final judgment on Honorable Tanya Cutchin. And that's your
Your Honor.
Reports to be an amendment on November 15th of 2019.
Right. I think that was amendment because there was a wrong case number on it, and we amended it for that purpose. But we're considering a final order and not an interlocutory order, again, for the same reason. In order for it to be interlocutory, it has to be addressing the subject matter where a final order has not already been entered. So I guess our basis for this is we already have a final order. Attorney has already been established. It's already been adjudicated. And so this is a final order in that it's a dead end order, not that it, because it doesn't have the authority to relitigate paternity again without a proper pleading allowing that. So I think that was the county's position here, Your Honor, is that it's not interlocutory. It's a dead end order.
Well, you'd agree our test isn't whether it's interlocutory or not, it's whether it is a final judgment is what has to be shown to invoke our jurisdiction. So whether we say it's interlocutory, we say it's void, the statute's pretty clear about it being a final judgment, at least the grounds that you asked for appellate review, correct?
I think partially correct, Your Honor, but again, I would argue Hill v. Manning that allows this court the discretion to review this as not interlocutory on this issue of paternity because it was already previously established.
Okay, well, Ms. Reeves, so we understand that it was previously established, but we do have several statutes that that have been adopted since some of the cases that do allow that to be reopened, so to speak, at least 3 that I can find actually, because you have 4914, you have 50-13.13, and you have 8-50.1, where even where it has been established, a party can ask for paternity tests, for blood tests, DNA tests, and challenge that. Now, and I'm not suggesting anything about whether or not anything was properly done, but that there are methods by which that can be done, right?
Correct, Your Honor, and I think you're absolutely right, but I think this applies to paternity in any other order, and that is precisely what is at issue here. For Rule 60, you have a 1-year statute of limitations. If you go down to Rule 60B6, you can't use that. Has to be extraordinary circumstances. For 50-13.3, there's a 1-year statute of limitations. And when you go to the new statute 49-14H, not only can you provide paternity test results as part of your motion in trying to have a previously established order set aside, you also have to lay out the grounds in that motion for fraud, duress, mistake, or excusable neglect. And we simply don't have that in the motion. We have one word outside of the recall for order for arrest that the county consented to. You have paternity. You have no statutory authority that is laid out in the motion, and just our basic Rule 7 under the Rules of Civil Procedure, any motion that is filed has to lay out the particular grounds upon which it is based. And this motion simply didn't do that. This motion says paternity. It does not invoke Rule 60 of any kind. It does not invoke Rule 50-13.3. Both of those, which are precluded by the one-year statute of limitations, nor does it invoke 49-14H, which says you have to lay out the grounds: fraud, duress, neglect, and your evidence. So in addition to that, there's a marital presumption. These parties were married, and it specifically says in that statute, nothing in this section rebuts the marital presumption. So that means there are 3 prongs under that one statute that this appellee could have used, right? But you don't find that in the motion. There were no paternity test results. He's asking for paternity to be set aside. There was no allegations of fraud, duress, mistake, or excusable neglect upon which the county could defend, prepare an argument, or even do discovery. The only things you have is the word paternity, and you have a 9-page transcript, which includes the cover page and the certificate of service in the back, where the defendant's only arguments to purportedly or with broad and wide discretion ask the court to set aside another order says, she won't let me see the kid. My name's not on the birth certificate. I don't know anything about the kid. And I keep texting her, but her brother is threatening me, which I objected, and that was sustained impliedly by the court because they told him to stick to the issue of paternity, and it's never raised. The only thing that's raised in the transcript by the judge is it appears that the entry of default, not the default judgment, but the date of entry of default appears to be stricken on that order, not stricken from the record. And if you look on that transcript, I believe it's page 5, the judge says, well, that's why. And then she says, is there anything else to Mr. Mabe? And he says nothing else. And she says she's ordering it. No,
Ms. Reese, sorry.
Sir, I'm sorry. Go ahead, Judge Murphy.
Under 4914H, it seems that we're just at this intermediate stage, setting aside issues with the pleadings, but we're just upon proper motion alleging these things. The trial court shall order, the testing, the paternity testing. So we're not even at the final stage of this where defendant needs to prove duress, fraud, mutual mistake, or excusable neglect. So to that extent, if we take it that everybody understood this is what he was going under, and I know it's a big stretch from your position, but if we got to that stage, aren't we just still at an interlocutory stage of this proceeding where all that's happened as of right now is the paternity testing phase, and we're not to the evidentiary phase at all?
I don't think so, Your Honor. I think that the statute is clear of what has to be laid out before you can even get there. I don't think the court can just say, because of the case law that's already in place, 8-50.1, the case law there says that the issue of paternity doesn't arise if it's already been adjudicated. So we have that. So I think that's why they have the extra step in that statute 49-14H, that you have to lay out the grounds. It's not just go order a paternity test, because that would be easy, right? Hey, I've got paternity here. I want to order paternity test. Let's just forego all final orders, and then we'll argue if you bring the paternity test back, fraud, duress, mistake, or excusable neglect. I think that's putting the cart before the horse, and I think that is interpreted in the statute to reach a result that was not the intent of the legislature. So I think all of those things have to be laid out, and the pleading doesn't do that. So even if you were to try to broadly apply that, it doesn't invoke the court subject matter jurisdiction because the pleading was not properly laid out. I don't think they had to make this statute to activate 8-50.1 and allowing the court to order paternity. That statute exists by itself. There was a purpose in putting the extra part of what appears to be Rule 60 B1, fraud, duress, mistakenness, excusable neglect in there, and then saying, notwithstanding the time limitations of Rule 60. In addition to that, you have the marital presumption that would need to be rebutted. Now, I would argue that maybe that would be part of the interlocutory process once you have met prongs 1 and 2 as to why the court should do that. But I don't think that the statute was meant to allow a litigant to just simply say paternity and insert this in afterwards. I think for all, just like all other pleadings, you have to put a party on notice so that it can properly defend. And we should not be, the county or any litigant should not be put in a place where we have to guess what statutory authority that you are filing your motion. Rule 7 is clear. If you're going to file a motion after a subsequent complaint, you have to lay out the grounds. And again, this motion just simply doesn't do it at all.
Ms. Reese, let me ask you another question. You mentioned the marital presumption a couple of times as we were talking about 14, so this might be as good time as any to address this. Can you point me in the record to where it says that they were married at the time? I looked at some of the record references in the briefs, and it just wasn't sticking out to me where there's evidence in here of the parties being married.
Your Honor, I will point you to the caption. Arguably, could they have been divorced at the time she filed this? Arguably, they could have. And it's not, let me look and see if it's in the final order. And I'm saying they're married, and I also say it in my brief that they were married at the time, and it's not contradicted in the appellee's brief.
But I guess I just don't see where that's supported by the record before us as I went through it. So
let me go to our page. I don't think it says it specifically here, Your Honor. I addressed it in my brief, and it is, which is in the record, and the appellee does not dispute the marital presumption in his brief. So I think that that is also before the court in the record in our briefs.
and just so we're clear on 4914, do you agree or disagree that these motions can be brought at any time? It doesn't matter if it's 2 years, 5 years, 20 years, or the like.
Well, since there's a
4914.
Since there is a lack right now of really any case law on 4914H, I think that's why the standard, the first prong, is so strict and requiring fraud, duress, excusable neglect, or mistake for that to be there, notwithstanding the time limitations of 1 year. I'm thinking maybe down the road, the issue of a reasonable amount of time is going to become an issue because it's not outlined in the statute. For the child support agency, it would almost be ridiculous for us to do the cases that we do. We're doing 69 to 100 absent the pandemic per day that we're in court 4 days per week. For somebody to be able to come back at 17, when a child is 17 and a half years old, and have paternity disturbed and set aside. So my argument would be that it would have to be a reasonable amount of time because there are public policies against bastardizing a child and overstepping the marital presumption.
But right now, what we see reflected by the words of the legislature and the invocation of the policy they wanted to do in 4914H is no time provision, correct? By plain language of the statute.
Correct, Your Honor. I think the only thing that we see is that notwithstanding the 1 year time limitation of Rule 60, do I think it gives perpetual? I guess it depends on what side you're standing on, but I would argue that a reasonable amount of time is still going to be the standard.
But it also says, or any other provision of law. So it's not limiting just to Rule 60's time limitations. It's saying any time limitations we're not going to say are upheld at this point.
I guess that's an argument to be made, Your Honor.
All right, thank you, ma'am.
Thank you so much, Your Honor.
Ms. Reeves, I don't think we can hear you, Ms. Reeves.
Can you hear me now? It just
Yes,
keeps beeping back and forth. I'm sorry. So I think the purpose of the law, Your Honor, is to provide equal access to justice, when you mentioned in 4914, but for all parties, not just somebody that's moving against paternity, but against a party who already has paternity established. And if this court allows the trial court, this trial court order to stand from October 22nd of 2019, that equal access to justice doesn't happen here. And such a ruling by this court will have catastrophic results for the agency and frankly for any party where we're forced to defend improper motions that lack grounds so that we can form a proper and accurate defense, which would include contacting witnesses, engaging in discovery. And in fact, the motion that was filed, it lacks a signature. So this motion, in addition to not having the proper grounds to invoke subject matter jurisdiction, it's not even signed. And that's not the intent of our Constitution, our legislature, or our common law. All of those things were put into place to provide not just equal access, but due process, proper notice, and uniformity, all the things that the appellant's motions lacked. Now, the order, you have an order entered here, not only without subject matter jurisdictions, for all the reasons outlined in my brief, my reply brief, and my argument here today, but it lacks any findings of fact or conclusions of law to support the ruling. Which is why we're all sitting here trying to guess now upon which authority the court could enter this order. So simply put, it's void ab initio, that it has no effect. And as I stated on page 5 of my reply brief, this order can be ignored. That's what our courts have said. However, as I also stated, that's not necessarily a smart thing to do when you have to keep coming before a judge in the context of child support, because child support amounts are always open. So this case is simply about respecting the process. That's all. If the defendant wants to challenge paternity, pro se or not, there's a right way to do it. But today we're asking the court not only to make sure that pro se litigants, for any matter, respect the legal processes that are in place and that have been built and that we're continually building on, as you see in 4914, based on decades and centuries of both wisdom and trial and error. Those efforts should not be for naught. We're asking this court to make sure that the trial court respects these boundaries and does what it's supposed to for the parties in these proceedings. And to remember
that, so when you're talking about being on notice and being able to defend your case, I mean, it's a blood test, right? And what are you going to do to defend against that?
Well, Your Honor, the appellee had an opportunity. This wasn't his first day in court. He was in court 4 years before that. 4 years before that. And he was in court at least 5 more times after that with counsel. This was his wife. He had an opportunity to come to court. He was properly served. He didn't show up for court. The paternity was established. Support has been withheld at a time where he was in transition with jobs, as you look into in the record. He appeared for court for several contempt hearings and had counsel. So he's had the opportunity. So to just simply say, oh, well, it's just a blood test. Well, there was court and there was counsel after counsel after counsel that he was appointed. And at this time, Your Honor, I think I'm running way into my rebuttal time. But yes, it's a blood test, but he doesn't reach the blood test until he properly invokes the court's jurisdiction after he ignored the first set of proceedings where it was established and then didn't even raise it anytime thereafter within that first year or any of the 3 contempt proceedings after that. He tried it pro se after the last contempt hearing where he dropped his counsel. So
Ms. Reeves, let me ask just two questions real quick to
Sure,
follow
Your
up on
Honor.
that. Is there anywhere in the transcript that shows that Guilford County requested specific findings of fact be included in the order? And was there any objection to moving forward with a hearing whatsoever based on the motion?
So, Your Honor, I think when the court asked him to present his motion, because we were there for his motion, that was the only thing that was there. Our objection to the motion was cut off by the court's questions. If you look at the end of the transcript where I asked the court to reconsider, I was about to say because it lacks subject matter jurisdiction, the judge just cut me off. And I mean, that's just where it is. We explained to the court that it was not a properly filed motion, that the paternity was already established, and the court chose to move forward with asking the questions on why didn't he do it sooner? And he didn't give an answer to that. He gave the 4 things that I gave you, none of which are bases for his motion, none of which invoke the court's authority. So, you know, for the county, this motion and this order are wild deeds in the chain of title, and they don't belong there. So to the extent that the motion is there and filed, the trial court had a duty to dismiss this motion and not allow it because it didn't properly invoke the subject matter jurisdiction. And Your Honor, that's my time. I'd like to reserve the remaining time for rebuttal.
Thank you, ma'am.
All right.
Thank you.
Thank you. All right, Mr. Melrose. And
Good
Mr.
afternoon.
Melrose, let me just say thank you for taking this on our pro bono program. We really appreciate your doing that.
Thank you, Your Honor, and I appreciate the opportunity to help out. And may it please the court, my name is Adam Melrose, and I represent Mr. Mabe in this action. And I believe the proper focus on this case is whether or not this is a procedural issue. The real question here is whether or not this appeal is interlocutory or not, and whether or not the trial court had subject matter jurisdiction to hear and order a paternity test, and whether or not this court has jurisdiction to hear this appeal. It's my position that this appeal was interlocutory and should be dismissed. The appellant, Guilford County, did not raise the interlocutory issue in its initial briefing, did not raise it when it filed its appeal. This appeal is not properly before this court. And even if this appeal was properly before the court on an interlocutory issue, there are multiple decisions, previous appellate decisions from the Court of Appeals that have stated that paternity testing does not affect a substantial right. So even if we reach the merits of whether or not a substantial right has been invoked, it's already been, that issue's already been foreclosed by prior precedent in this court. The trial court had subject matter jurisdiction to order a paternity test pursuant to the statute that's been discussed during the prior argument, 4914 subsection H. Now, this is a new statute, relatively speaking, to 2012, and I think that is important to take into account, that this is a new statute, because the vast majority, if not all of the case law that has been cited that discusses subject matter jurisdiction in the context of a request for paternity testing after a judgment's been entered is all pre-2012. This 2012 statute was passed for a reason. The reason it was passed was to give an additional avenue for contesting orders of paternity. This order, I think the key language in this 4914 subsection H is the language that says, notwithstanding the time limitations of Rule 60, or, comma, any other provision of law, comma, you can advance this motion. So to the extent that any other statute, any other rule of evidence forecloses or changes the time limitation, this seems to be the legislative's intent to provide an additional avenue should you meet the two requirements that are down below the notwithstanding language, which is the paternity test plus whether or not there was any fraud, duress, mutual mistake, or excusable neglect. Now, I think what is key to finding the trial court had subject matter jurisdiction was the only requirement that the trial court had to find was that the father, the putative father, has alleged one of those four elements, has either alleged fraud, duress, mutual mistake, excusable neglect. It does not require a finding on those issues. As a matter of fact, I think the most accurate reading of that statute is that after there is an allegation that meets that first subsection, those four standards, those four possibilities, you then, it says the trial court shall, not may, says the trial court shall order paternity testing. That is where we are currently at in this process. We are not, the trial court has not set aside paternity. We have not reached the conclusion of the analysis under subsection H. After the paternity test is taken, that is when, depending on the results of the paternity test, the trial court will need to make a finding on whether or not there is any of those four factors laid out in the first subsection. So we're quite frankly just not to that point yet, which is why this appeal is interlocutory. Now, had the paternity test, had the order of paternity already been set aside, it would be a different question before the court today. I think that would be a far different appeal and a far closer question. However, all that's been ordered is a paternity test, period. The trial court has not made any ruling as to whether or not it's going to set aside paternity in this case, and what the trial court is not required at this point in the process to have found fraud, duress, mutual mistake, or excusable neglect. All it has to have happened is that the Mr. Mabe have alleged it in some fashion. I know there's been a lot of discussion about the form of the motion and the contents of the sort of the hearing transcript. However, I don't believe that this court should reach those issues today. If we are at the point where we are looking at whether or not the form of the motion was correct, or whether or not the correct magic words were invoked at the hearing, we're already into a question about whether or not the trial court was abusing its discretion in granting the motion. We're far beyond the question of whether or not the trial court had the subject matter to even entertain the motion and grant the motion. This court should never reach the question of whether or not the trial court abused its discretion. If we are at that point, then this appeal is interlocutory as already established by precedent. Yes, this is a somewhat unique and it's an issue of really second impression for this statute. It's only been raised once on an unpublished case in the past. And I think that Simpson versus Simpson case is very instructive. In that case, they didn't reach the merits on whether or not whether or not there was a correct allegation or findings on those orders. It was just dismissed as interlocutory for the reasons I've already previously stated about paternity testing not affecting the substantial right. I know that Guilford County raises additional potential substantial rights in their reply brief. Sort of my only response to that is they were not raised in the initial brief, and it should not be a consideration for the court, not properly before the court, and didn't comply with the North Carolina Rules of Appellate Procedure. This court should also not treat this matter as a petition for certiorari, which seems to at least be what Guilford County seems to be stating to some degree, that you still would have, yes, this court and panel has the ability to treat it as a petition for certiorari. However, there are still additional facts that need to be found in front of the trial court, namely and most importantly, whether or not this paternity test is going to come back as Mr. Mabe, more or less likely father of the child, which will then lead us closer to the question of whether or not the two subsections of 4914H have been satisfied. And at that point, it's going to be a much better time period for this panel to address that issue, because whether or not they grant Mr. Mabe's motion to set aside paternity or deny it, that would be a final order on the question of paternity.
Mr. Miller,
yes.
Let me ask. I really have a lot of concern with this motion at record page 66. How would anybody know, even a good attorney that only does child support issues, know going into a hearing on this matter that this is going to have anything to do with 4914H?
Yes, Your
I
Honor.
just don't see how this puts the party on notice whatsoever about what's going to be at issue in a hearing.
Your Honor, I agree. I agree that the form of the motion is not the best. It is a pro se motion with no real allegations or cites to case law, and I acknowledge that fact. However, I think if you look at the record, most importantly, I think the Guilford County did not ask for a continuance to further investigate the motion. And I think there was an understanding of that hearing based upon the testimony of Guilford County's counsel at the hearing that he was asking for paternity tests. The words paternity test were mentioned multiple times by the court and at least once by counsel for Guilford County. So I don't think that there was any real confusion as to the purpose of the motion, even if the specific statute was not referenced either by the court or by the movement. In addition, I don't believe there's much that Guilford County could have done even if they knew which statute was being cited. The only requirement for the ordering of the paternity test is that the defendant the putative father alleges one of those four rationales under subsection 1. It's not really an evidentiary hearing to the extent that they're going to get into the merits of whether or not those have been satisfied. It's just a simple allegation. But Your Honor, I do agree it's not the best laid out motion, but there are lots of interlocutory orders and lots of interlocutory matters that are possibly not handled in the best way possible, or don't facially meet the requirements under the rules. However, again, it's still interlocutory. It's still an interlocutory order that should not be addressed by the court, especially given the fact that this does not affect a substantial right. Paternity testing is not a substantial right.
So is it Mr. Mabe's position then that even though this motion is lacking in detail and lacking reference to statute, that while if we were looking at it, it may not satisfy 4914H and the allegations that have to be made, it does at least invoke the trial court's jurisdiction to make some type of ruling or dismiss the motion or anything like that? That it does invoke the power of the trial court to rule on this document?
Yes, Your Honor, I believe that is an accurate statement of Mr. Mabe's position. It's the jurisdiction is just whether or not the trial court had the power under any statutory authority to issue a ruling. And I do believe it would be incumbent upon the other party to make an objection if there was some question as to lack of notice. There was no discussion about lack of notice. I know that there was discussion about what exactly Mr. Mabe was asking for, what exactly his grounds were, and the trial court did go at least ask a few questions as to the grounds for his motion. Could it have been more eloquently put? Absolutely. There is no doubt that it's bare bones at best. However, it was sufficient to invoke the trial court's jurisdiction to hear the matter, to hear whether or not to hear the question of paternity. The trial court had jurisdiction. If the court had jurisdiction, is Mr. Mabe's position that that the order is not prima facie invalid. Even if the statutory requirements were not met, even if the trial court abuses discretion, which I'm not conceding that the trial court did abuse its discretion, but even if it did, it's still an interlocutory order and is still not in front of this. It should not be in front of this court on an abuse of discretion standard.
And before the trial court, there was no motion by Mr. Mabe to amend his motion to reflect the evidence or reflect the arguments being made, correct?
Your Honor, that's correct. There's not. Does the panel have any further questions? Otherwise, that's really all the argument I have. Thank you, Your Honor.
Yep.
Oh, go ahead. Thank you.
There we go. Couldn't get my mouse to cooperate. All right. Ms. Reeves, any rebuttal?
Yes, thank you so much, Your Honor. If it please the court. Counsel mentioned the Simpson v. Simpson case. I think that case actually helps the county out. In the Simpson v. Simpson case, what happens there is you have a movement who files a Rule 60 motion, and the trial court dismisses it, says it's untimely. When this defendant came back to the court, which is the same thing that Mr. Mabe can do, if this court reverses the trial court's order, he came back and he filed a proper motion invoking 4914, 110, 132, 50-13.3. So that is the difference between these two cases. We had a properly filed motion, and then we have our motion here that's not signed that says paternity. And I would like to direct the court back to 49-14. From what, if we take counsel's reading and interpretation of this statute, that all you have to do is say paternity, and 4914 allows that. I beg to differ. 4914H says that the court can set aside paternity upon proper motion alleging fraud, duress, mutual mistake, or excusable neglect. If you have a proper motion alleging those things, the court shall order the parties to submit to genetic testing pursuant to 8-50.1. We don't have a motion in this case, a proper motion alleging any of those. If we take counsel's interpretation that you can just say paternity, that turns this provision of 4914 from a motion to set aside paternity to a motion for paternity. And that's not what we have. This 4914 is to allow the court jurisdiction to set aside a previously established order. That is markedly different than a motion for paternity. That is not what this statute is granting. So I think the plain words of this statute say upon proper motion alleging, the court shall order. And we don't have that here. So the reason it was passed is in the event that you have gotten past the interlocutory child support order to establish support and to establish paternity, that you get to set aside an order. That's what makes this order not interlocutory. We already have a final order. All of the cases that were cited by counsel, where the orders were interlocutory for paternity, paternity wasn't established. We have that here. Paternity is established. And so, Your Honor, we just ask that you strike the trial court's order, and Mr. Mabe, the appellee, is not prejudiced by any of this. Like everyone keeps saying here today, 4914 allows it to be invoked past the 1-year statute of limitations. And just as the defendant in Simpson v. Simpson did, he could go back to the drawing board. I don't think it's the county's responsibility to ask for the matter to be continued, for us to ask for a continuance, for the defendant to fix his pleading. The case law is clear. In order for the court to get subject matter jurisdiction, there has to be a proper motion alleging. That's my time, Your Honor. Thank you so much for having me here today.
All right. Well, thank y'all very much for your arguments today. And court is concluded.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is adjourned.